Joining me now with more criminal defense attorney Joseph Tully. Joseph, thank you so much for joining us. Great to have you with us. Now, we just heard from our reporter about what prosecutors have planned for this week. What was today's hearing about, and what did you think of the evidence presented by the prosecution so far?
So, in terms of today's hearing, it was very standard of what you would expect to see. A lot of times people don't know that with felony charges, it's actually a two-step process. So, everybody knows what a jury trial is. You have all the witnesses, the prosecution presents everything to the jury. So, that's sort of like a movie. A preliminary hearing, if a jury trial is like a movie, a preliminary hearing is like a movie preview. It's not 2 hours long, it's 2 minutes long. This is going to be a 5-day hearing, which is long, but it's not going to be as long as the jury trial will be. So the prosecution is seeking to kind of outline their case, give a preview, so to speak, to the judge of what their case is to show the judge that they have enough probable cause to proceed to trial. As you mentioned, it's a very low bar. The prosecution only needs to do probable cause, or the legal standard is probable cause. And so it's very low. As long as they establish some kind of suspicion and it's reasonable, the judge will certify the case for jury trial.
And digging into that, given what we've seen so far, do you think there's a chance this wouldn't go to trial, or would you say it's a slam dunk?
I would say it's a slam dunk at this point. A lot of times, preliminary hearings do have a function, but over the decades, in my opinion, it's been very eroded. It's very similar to almost a rubber stamp procedure at this point. And that's in general. Speaking in this case, based upon the evidence that's been shown so far, I think the prosecution is well on their way to establishing the legal standard of probable cause as to the elements that they've charged Mr. Robinson with.
And it looks like the defense is really focused on taking the death penalty off the table. What do you think they'll need to do to succeed?
I I don't know that they will be able to succeed. I think that would be very unusual. I would not predict that. If I was betting, I would bet against that. I think the prosecution has enough because the death penalty is the big um, is the biggest issue here. If you're a defense attorney, the first thing that you want to do, you're in triage mode. You want to save your client's life. So the very first thing that you would do, just as an ambulance driver arriving to the scene, okay, can I save this person's life? Once you establish that you can save their life, then you start working on other things. Um, so here, the defense attorney is rightly focusing on the death penalty as their main point to defend against. And they are objecting, they're making legal arguments, they're doing everything that they can to prevent the prosecution from being able to successfully establish the elements that they need to prove to a probable cause that aggravated circumstances happened. So, in other words, they can't just prove that this was just a regular killing, regular murder. They have to prove aggravating circumstances. And what they're going with is that, well, he shot into a crowd of people and other people could have been killed. Judge, that's aggravating and that qualifies for the death penalty.
Now, the defense was able to cross-examine some of the prosecution's witnesses today. What did that tell you about their strategy?
So I think they're doing everything very much by the book. They're being very aggressive, which we do need that. We need defense attorneys to be aggressive. You never know when you have an innocent client. You never know when the government just simply has it wrong. And really, their job is to defend the Constitution, and they're just doing it through this case. So they are being very aggressive, and that was surprising to me. But it should be reassuring to all of us that people are out there sort of defending the Constitution. And to me, I didn't see anything out of the ordinary. They were doing their job. They were objecting. They were making legal arguments, trying to keep every piece of evidence out. Basically, their approach is, okay, prosecution, you think this is going to be easy? I'm going to make it as hard as possible. This is not going to be a cakewalk for you. I'm going to make you work for every single thing, and you're going to have to earn it.
And more broadly, Joseph, what stood out to you the most in the hearing today?
I think that the prosecution, normally speaking, they do more of a skeletal outline. Again, this is sort of like a movie preview. You don't give away everything. You give away just enough to get people interested in the movie. So same thing in the preliminary hearing. They don't want to show all their cards to the defense. They want to show the minimum possible, but they still want to win. They still want to establish the probable cause for the hearing. And what stood out to me is that the prosecution is really going a little bit further. They're showing a little bit more cards. And what's been reported is that they want to combat some of the misinformation, maybe some conspiracy theories that have been circulating. So they're going a little bit above and beyond what a prosecution normally would do, I think, because of the public nature of this case, because this is such a media centered case.
Definitely a lot of eyes on this. Joseph Tully, thank you so much for joining us.
Thank you for having me.